making a false statement in the affidavit that he has done something which has given a what is it, public impact. We will not allow it. We will not
My
allow.
lord, my lord,
You keep on making a submission. You are tightening the noose. That's it.
my
If
lord,
you
I
want,
was
you just mute your mic. Listen to the order. You ought to have gone through the law before you settle the brief, before you file the wakalatnama, not later. This is a duty on the council. Don't play with the court.
Item number 2.
My lord, in item number 2, I am appearing on behalf of the petitioner, my lord.
Very good.
I appear for the registrar.
My lord, may I humbly submit, my lord?
Yes. Yes, Mr.
Yes, my lord. My lord, as this matter has been satisfied with our prayer file notification number 6362 RG dated 12/7/2024, my lord may be kind enough to dispose the instant PIL matter as our prayer has been satisfied, my lord.
No, there's a very important question. My lord, I appear for the registrar general.
Yes. And where is the writ petitioner, Mr. Radha Mohan Roy?
My lord, he is in the court, my lord. My junior is
Mr. Sanjay Das.
Yes.
When did you enroll, sir? You please come closer to the mic.
Your Honor, 2014. WB, my enrollment number is WB 1803 2014, Your Honor.
Because in your all right, in your writ petition, you have stated that let us see the prayer.
Paragraph 2, page 3.
The petitioner herein is an advocate by practice and a law-abiding citizen. The petitioner has about 10 years of experience at the bar and has been associated with many matters which have been brought about social impact and have made a difference in the lives of common people. Can you give us one instance where you have filed a PIL, where you are part of a social organization, or you're a member of the Bar Association?
Yes, Your Honor.
And whether you have contributed for a social cause. West Bengal was very severely affected by Amphan flood, cyclone. What did you do for that? Don't turn back. Don't turn back. Face the court.
Yes.
You are the petitioner. On the second day, when Mr. Radha Mohan Roy said it's so urgent, heavens will fall if the matter will not be listed, I said, please ask your client to be present. You are not present. The person who is standing behind you, we don't know his name, Somenath Sanyal. He mentioned the matter twice. On both occasions, we requested him to inform you that you should be present. Then suddenly they said they want to withdraw the matter. We are not fools sitting here. We are not fools. Never play with the court. If you want this and this to remain on your shoulders and neck, you better behave yourself. Okay. So we are not permitting you to withdraw the matter. And according to Mr. Radha Mohan Roy, he says his prayer stands fulfilled. It is the most, what do you say? We don't want to use any harsh expression. It's an uncalled for submission, which outrightly we reject. Mr. Roy should not have made that submission. He was part of the panel of the central government, appearing for the central government. I think he appeared for the income tax department also. I'm not very sure.
But now I have resigned from.
Yes. We know. So therefore, there should be some sense of responsibility to the court. On the second occasion, when the matter was mentioned, or even on the first occasion, after the vacation bench directed the matter to be listed before the regular bench, we advised your counsel on record, Mr. Radha Mohan Roy, have you please go through the law on the subject, whether such a prayer was maintainable. In spite of that, the counsel was not responsible. He did not have that. But subsequently, he started sending Mr. Sanyal to keep on mentioning before the court. So therefore, As a petitioner, you did not go through the legal position. Your advocate on record also did not want to go through the legal position in spite of having been indicated, nor the counsel whose also name finds place in the earlier orders who mentioned the matter twice. So therefore, you have to be dealt with very severely. This is not a playground.
Yes.
We are not hearing you, Mr. Rai. We are not hearing you, Mr. Rai.
One humble submission, my lord.
Yes.
My lord, actually, I was not, means my junior was there. I met an accident, means I got a hairline fracture in my ligament here in my.
You
For
please
that
take
reason,
rest.
I was not coming, my lord.
No. It's better to immobilize yourself.
No,
Please
now
take
I have recovered,
please
my
take
lord.
doctor's advice. Please
My lord,
don't
we all
strain.
are learning from my lord.
Otherwise,
My
the
lord has,
hairline will become a very serious issue. Hairline fracture at this age, it should not be ignored. Okay.
no, my lord has observed that I was sending my junior. Actually, for that reason, I was sending because I was not able to move.
No, irresponsible, sir. Irresponsible. As an advocate, member of the Calcutta Bar, said to be practicing for 10 years in a chartered high court with making a false statement in the affidavit that he has done something which has given a public impact. And he has now come out with the truth that he has done nothing. He has done nothing. And all of you are trying to convert this this chartered high court into a football ground. We will not allow it. We will not
my
allow
lord,
it.
My lord,
you keep on making a submission. You are tightening the noose. That's it.
My
if
lord,
you want, you just mute your mic. Listen to the order.
My lord, one more thing, my lord. One more thing I want to submit. My lord, we all are student of law, my lord, and
Yes.
I was fortunate
we had to
enough
remind
that,
you, Mr. Radha Mohan, we had to remind you to go through the law. We had to remind you.
My lord, after that,
you ought to have.
not listed.
Please hear us.
My lord.
You ought to have gone through the law before you settle the brief, before you file the wakalatnama, not later. This is a duty on the council. Don't play with the court.
No, my lord. No, my lord. I was fortunate enough that I learned a lot of law about income tax from my lord. But I was fortunate enough.
This writ petition
kindly not be asked.
Was filed as a public interest litigation. By one Sanjoy Das, son of Sri Haru Das. In the writ petition, the petitioner in paragraph 2 has stated that he is an advocate by practice and a law-abiding citizen of this country, semicolon, has about 10 years of experience at the bar and has been associated with many matters which have brought about social impact and have made a difference in the lives of the common people. In paragraph 3, the petitioner would state that he is a public-spirited person and has devoted his life for the purpose of addressing various social causes, including upliftment of the poor and needy. The prayer sought for in the writ petition is to issue a writ of mandamus commanding the Registrar General of this court to modify the notification dated 24/5/2024 so far as it assigns the rooster/determination of presiding over police inaction / overaction related matters to a particular single bench of this court. The matter was moved during the summer vacation before the Honorable Division Bench, and by order dated 6/6/2024, the Honorable Division Bench ordered passed the following order. Please quote this order. 6/6/24. As could be seen from the above order, the Honorable Division Bench had expressed its concern, namely whether the allotment of determination by the Honorable Chief Justice can be subject to judicial review. The matter was directed to be placed before the regular bench for further hearing. Subsequently, Mr. Radha Mohan Rai, learned advocate, appearing for the writ petitioner, circulated a letter dated 10/6/2024 addressed to the Registrar General referring to the mention made before this court on 10/6/2024 to enable the matter to be heard on an urgent basis. When the matter was listed on an earlier, when the matter was mentioned before this court, Mr. Radha Mohan Rai was advised to go through the legal position on the subject as to whether the allotment of determination of cases by the Chief Justice can be subject to judicial review. It appears that this advice was not well taken by Mr. Ray, and subsequently, one of his colleagues, Mr. Sominath Sanyal, appeared before this court and mentioned the matter for early listing. The same advice given to Mr. Ray was also given to Mr. Sanyal to go through the legal position. Mr. Sanyal was also advised to ensure the presence of Mr. Sanjay Das, the writ petitioner, before this court on the next hearing date. Subsequently, also, there was a mention for early listing, and the matter was running in the list. And subsequently, the learned advocate for the appellant sought to withdraw the writ petition on the ground that the relief sought for has been relief sought for stands satisfied as there was change of determination by a subsequent notification issued by the High Court. This prayer was refused, and the matter has been listed today. Listed today. We have heard Mr. Radha Mohan Rai, learned advocate appearing for the petitioner, has directed the petitioner, Mr. So-and-so, is present in court. Since the petitioner in the writ petition had stated that he has been associated with many matters which have brought about social impact and have made a difference in the lives of common people, and that he is a public-spirited person and has devoted his life for the purpose of addressing various social causes, including upliftment of the poor and needy, the court queried the writ petitioner, Sanjay Das, to place before this court as to what was done by him which have brought about social impact and have made a difference in the lives of common people, and as to how he claims himself to be a public-spirited person and that he has devoted his life for the purpose of addressing various social causes, including upliftment of the poor and needy. The answer to the query was an emphatic no or a stoic silence. Thus, it is clear that what has been stated by the writ petitioner Sanjay Das in paragraph 2 and 3 is absolutely false and unbecoming of a person in the legal profession. Coming back to the main issue as to whether a writ petition with a prayer as sought for was maintainable, we need not labor much on that, as we are guided by several decisions of the Honorable Supreme Court.
The 2026 SSC is a constitution bench.
In State of Rajasthan versus Prakash Chand, 1998, 1 SEC, page 1. The Honorable Supreme Court has clearly stated that the administrative control of the High Court vests in the Chief Justice alone. This decision was taken note of in Campaign for Judicial Accountability and Reforms versus Union of India, 2018, 1 SEC 196, wherein the Honorable Supreme Court observed that as far as the rooster is concerned, as has been stated in Prakash Chand, the Chief Justice is the master of the rooster, and he alone has the prerogative to constitute the benches of the court and allocate cases to the benches so constituted. In the said case, it was further pointed out that there cannot be any direction to the Chief Justice of India as to who shall be sitting on the bench or who shall take up the matter as that touches the composition of the bench. Further, it was pointed out that the authority which is conferred upon the Chief Justice is vested in high constitutional functionary, full stop. The authority is entrusted to the Chief Justice because such an entrustment of functions is necessary for the efficient transaction of the administrative and judicial work of the court. Full stop. The ultimate purpose behind the entrustment of the authority to the Chief Justice is to ensure that the Supreme Court, within bracket court, is able to fulfill and discharge the constitutional obligation which govern and provide the rationale for its existence. This one is relying by psychiatry. Which one?
Lord, I was citing 2026 SCC. 2026 SCC 304, paragraph 34.
Indoor development.
Yes. This is by a 5-judge constitutional bench. Paragraph 34 is at page 340.
The Constitutional Bench of the Honorable Supreme Court in Indoor Development Authority, within bracket, recusal matter -5J bracket close versus Manohar Lal, 2026 SCC 304, held that if requests for recusals are acceded to for the asking, litigants will be unscrupulously taking over the rooster-making power, rooster-making power, para 34, powers of the Chief Justice, and that would tantamount to interference with the judicial system, but mighty to have a particular bench by employing several means and putting all kinds of pressures from all angles all around. There are other decisions also on the very same issue, and it has been conclusively held that the right of the Chief Justice in finalizing the determination cannot be subject matter of, cannot be tinkered with at the option of a petitioner, and more particularly in the case on hand by an advocate stated to be practicing before this court. Despite being advised to go to look into the legal provision, the advice fell into deaf ears and was not taken in the right spirit. Therefore, we are of the clear view that the writ petition was a clear abuse of process of the court. It is probably an attempt to intimidate the court and to directly interfere with the jurisdiction of the Chief Justice in finalizing the roster. Apart from that, we had already pointed out that the writ petitioner has made a false statement claiming to be a public-spirited person and having served the cause of the people, and there is nothing on record to indicate so, nor the petitioner who was present in court today has been able to say anything to us as to how he is a public-spirited person and how he has devoted his life for the poor and needy. Therefore, the writ petition has to be dismissed.
Rule 61 and 62.
The High Court at Calcutta has framed rules relating to applications under Article 226 of the Constitution of India. In Chapter 2 of the said rules, Chapter 2 of the said rules deals with public interest litigation. Rule 55 states that the rules incorporated in Chapter 2 will be applicable only to public interest litigation as defined in Rule 56, in addition to those contained in Chapter 1. Rule 55 defines public interest litigation to include a litigation, the subject matter of which is a legal wrong or a legal injury caused to a person or to a determinate class of person by reason of violation of any constitutional or legal right or any burden imposed in contravention of any constitutional or legal provision or without authority of law, or any such legal wrong or legal injury or illegal burden is threatened, and such person or determinate class of persons is, by reason of poverty, helplessness, or disability, or socially or economically disadvantaged position, unable to approach the court for relief, and for redressal of which any member of the public not having any personal interest in the subject matter presents an application for an appropriate direction, order or writ in this court under Article 226. The rule also contains a second limb which commences with a non-obstante clause, which will not be applicable to the case on hand. As could be seen from the writ petition, the petitioner cannot bring the case under any of the under the definition of public interest litigation as defined under Rule 56 of the rules of the said rules. Therefore, this is one other ground on which the writ petition has to be summarily dismissed. Having found that the writ petitioner has abused the process of this court, attempted to intimidate the office of the Chief Justice, and made false statements about himself in the writ petition, and in spite of having been advised to examine the legal position and not taken the advice in the proper spirit, we have no other option except to dismiss the writ petition with exemplary cost. In this, at this juncture, we may refer to Rule 61 of the said rules. The said rule deals with the power of the court to take appropriate action in a case a public interest litigation is found to be frivolous. If the rule states that if a division bench, while disposing of a public interest litigation initiated in terms of Rule 57 of the rules, finds the same is a frivolous one or made with malified intention or both, it may not only impose exemplary cost against the petitioner, but also debar him from presenting any public interest litigation in future before this court for such a period as it thinks fit. We have recorded our reasons as to why we have come to the conclusion that the writ petition is absolutely frivolous with a view to intimidate the office of the Chief Justice, which obviously would show malified intentions, and therefore the court will be well justified in dismissing the writ petition with exemplary cost on the writ petitioner, and also to consider as to what other order that should be passed against the writ petitioner in terms of Rule 61 of the said rules. For the above reasons, the writ petition is dismissed with cost of rupees 50,000 payable to the West Bengal State Legal Services Authority within 10 days from the date of receipt of the server copy of this order. Considering the reasons set out above and the conduct of the writ petitioner, who is stated to be an advocate practicing in Kolkata, this is a fit case where the power under Rule 61 has to be exercised, and accordingly the same is exercised, and the petitioner is debarred perpetually and eternally from presenting any public interest litigation in future before this court. Full stop. Yes, now you come to the other supplementary list.
My lord, may I humbly pray one thing, my lord? Just a humble prayer, my lord. My lord, kindly, please don't be so harsh upon us, my lord. If the cost can be removed, my lord. Humble submission with prayer.
Please call the next case. Call, then you take the papers.
Supplementary